Good afternoon, ladies and gentlemen, and welcome to this IT governance webinar on the first steps toward GDPR compliance. My name is Alan Calder. I'm going to be your host this afternoon. The webinar is planned to run for about 45 or 50 minutes of me talking to you about getting started on the journey towards GDPR compliance, and at the end of it there will be an opportunity to ask questions. If during the webinar you find there is a question that you would like to ask and you can't because you're on mute and I'm in full flow, then please do use the question functionality in the GoToWebinar control panel, which should be sitting on your screen. It's one of the grey panels. If you click on it, you'll find there's a box you can type questions into, and when we come to the Q&A session of the webinar, what I'll do is I'll go through all of the questions which have been asked, and I will answer them in the order that they've been asked. So that's how you get questions asked and answered. The most common question is, are the slides going to be sent out? Yes, they are. So my background is in general business. I set up IT governance more than 15 years ago to be the single source for organizations who wanted to be able to access a range of books, tools, documents, training, consultancy, software, all designed to integrate and operate together, and which might be used by them for any one of a wide range of activities which they are tackling as part of their move towards cybersecurity and effective governance of their technology and IT environment. I've written a number of books around IT governance and cybersecurity. The oldest of them is going to be heading in towards its 7th edition next spring, and is still the Open University's postgraduate textbook on information security. IT governance as a business, as I said, is a specialist in being a one-stop shop for everything to do with the governance, risk management and compliance requirements of companies, and we work with organizations of all sizes from small to substantial, and we work across all sectors. We deal particularly around cybersecurity, cyber resilience, penetration testing, PCI, incident response, and of course a significant activity around privacy, the Data Protection Act 2018 in the United Kingdom, and the General Data Protection Regulation. Today I'm going to be talking about the regulatory landscape, a quick overview of that and the territorial scope of GDPR under the Data Protection Act, the principles of the EU GDPR, the way in which breach notification rules operate in respect both of data controllers and data processors. We'll look at data subject rights, and in that context also at the changes to consent that have come into place since the old Data Protection Act 1998. We'll look at the specific processes and obligations on data processors, the role of the data protection officer. We'll touch on international transfers, and we'll look at the role of regulators and how that operates across Europe. If you're just starting on your GDPR compliance journey, you're not alone. Data suggests that something like about 75% of the UK's companies are not yet GDPR compliant, even though it came into effect after a 2-year transition period back in May this year. In the United Kingdom, the GDPR is brought into effect both because it's a regulation, the General Data Protection Regulation, as the title suggests, and regulations under the EU treaties become law in member states by virtue of the treaty, but it's also incorporated directly into UK law through the Data Protection Act 2018. And what the Data Protection Act 2018 does is it essentially takes all of the main body of GDPR and simply writes it into the UK's rule book, and where there are derogations or opportunities for member states to set their own rules, it selects how it wants to set those rules and builds them into the Data Protection Act. So whether you're talking about GDPR generally across the European Union, outside of it, or in the UK, or you're talking very specifically about the Data Protection Act 2018, the core principles, the core requirements are all exactly the same. Understanding international transfer is going to be particularly important for companies inside the UK, because depending on what happens, if anything does actually happen vis-a-vis the proposed exit or Brexit from the EU, the UK will become a third party under EU regulation, and it will then fall into the same set of restricted activities in respect of personal data as are companies like Mexico and Chile and others. So quite complex for organizations looking at the Brexit transition, quite complex in any case, but I'll try and touch on those through the later parts of this session. So just briefly to go back to the point about directives and regulations. Directives are issued by the European Commission, and they tell member states to write a law which will put into their law or legal system specific requirements that have been agreed across the European Union. There is some latitude for different member states to determine how they implement that. Usually the implementation is much the same, but there's quite a lot of room for member states to be somewhat more heavy in terms of what they require than others. A regulation, as I said, goes into effect by virtue of the fact it's a regulation, and when a regulation is put in place, it's essentially the same or applied in essentially the same way across all 28 member states, which means that you get a level playing field for countries dealing in the context of that particular regulation. The GDPR therefore doesn't require implementing legislation. It's had it in most member states of the European Union, and it came into effect on the 25th of May this year, so just around 6 months ago. And the data protection model under the GDPR starts with us, the data subject. We, natural persons, living human beings, have rights. And as data subjects, we might decide to hand some of our data over to a data controller. A data controller is typically an organization, but could also, under some circumstances, be an individual, typically an organization. And the data controller may or may not outsource some of that processing to a data processor. So the working assumption of the GDPR is that in most cases, a controller will process the data itself. It may decide, for instance, with payroll, that it wants to contract with a third party to carry out some specified processing activities. All of that takes place under the supervision of the member state supervisory authority. In the UK, that's the Information Commission's office. The ICO was the supervisory authority under the previous form of data protection legislation in the UK, which is the Data Protection Act 1998. The Data Protection Act 1998 came into force as a result of a European directive on data protection back in 1995. And that act is now superseded by the Data Protection Act 2018, although if you were in breach of the previous version of the Data Protection Act, you can still be prosecuted, you can still be fined for breaches that took place. But you can only be fined for breaches that took place prior to May the 25th under the old Data Protection Act. After May the 25th, you'd be fined under the new Data Protection Act. So the ICO, she has the task of supervising data controllers and the way the entire operation works. Data controllers can transfer data to third countries. A third country is a place like America, for instance. It's outside the European Union, and it may or may not be recognized as having an adequate data protection regime. If Britain goes ahead and leaves the European Union, it will be a third country, and therefore everything which I tell you during the next 45 minutes or so about third countries will apply to Britain as well. You can also share data with third parties, either as a joint controller. So for instance, two organizations get together to promote an event, you run a single website, you collect data on that website and you share the data. That's perfectly legitimate as long as the data subjects know what's going on and you've dealt with the requirements around privacy notices and the lawful basis on which both of you will process their data and you're transparent. Third parties can provide you with data, so you can still buy a mailing list. There's nothing that stops you from doing that, but there are specific requirements in place that ensure that mailing lists that you're buying are being bought, if you like, with the proper knowledge of the people whose data is recorded on them. So controllers have duties those duties pretty well match the rights of data subjects. We have the right, you and I as data subjects, we have the right to know what's being done with our data. We have the right to ask somebody to stop doing it, and the controller has an obligation to help us achieve our rights, to facilitate the exercise of our rights. So the onus on the controller is quite substantial, and the Information Commissioner can assess compliance, can enforce compliance, can issue fines, can issue guidance, can issue prohibitions, can do whatever they see broadly fit within a legal context to ensure that the regulation is fully and properly enforced. As a controller, you need to be making sure that where you're sharing data with third parties, you've dealt with security, you've dealt with guarantees around how the data will be protected. And if you're transferring it out of the European Union, you need to be able to meet the requirement that the data is as safe outside the European Union as it is inside it. And that's not just in terms of security, but also in terms of legal protections. There are 28 member states, so there are at least 28 supervisory authorities. Germany, for instance, has a supervisory authority for each of the federal states. But in each country, in each member state, there has to be a single lead supervisory authority. And those lead supervisory authorities are in turn supervised by the European Data Protection Board. That's a bit of a misnomer because the EDPB is far more of a coordinating and enabling body. Its role is to ensure that the regulation is consistently applied throughout Europe, that where there are differences in interpretation between different jurisdictions, those differences are ironed out, so that there will in fact be a level playing field, both for organizations trading in the European Union, but also for individual data subjects who might want to be sure that their data is being protected in substantially the same way by any organization operating within the European Union or indeed outside of that. So the role of the European Data Protection Board is pretty fundamental, and the rights of data subjects are thoroughly reflected in the way the European Data Protection Board and the supervisory authorities operate. So, as I said, natural persons, somebody who is alive, dead people don't have rights. Natural persons have rights in relation to how their data is processed, to that processing being protected, and also to the unrestricted movement of their data within the European Union. This regulation applies to controllers and processors anywhere in the European Union, irrespective of whose data you're processing. So if you're a controller in the European Union and you're only processing the data of people who live in Afghanistan, you still have to comply because you are in the European Union. It also applies to organizations who are outside the European Union, but who are processing the data of European Union residents. And that's got nothing to do with their nationality. It's simply the fact that if you're providing services into the European Union, then you must comply with the GDPR. So the territorial scope is very wide. You can think of GDPR as being, in effect, the first global data protection regulation, and you will see many organizations in the US right now who found compliance a little bit too difficult. So when you try and log on to their website from within the European Union, you'll get a page not found. Sorry, it's too difficult to talk to you, so please go away response from that website. Many other organizations in the US have worked out that it's not that difficult to comply and have gone ahead and complied, but more on that towards the end of this webinar. So territorial scope is very substantial. The material scope is also substantial. It applies to any data that's going to be processed by automated means, partly or wholly, and it applies to any data that is going to be put into a filing system or is intended to be put into a filing system. So a pile of visiting cards in the bottom of a drawer in a jumble is not a filing system, so they probably don't have to comply with GDPR in respect of those cards. But the moment you put them into a Rolodex or upload the data into a CRM system, that's the point at which you're putting personal data into a structured filing system, and you're within the scope of GDPR from a compliance perspective. And there are specific things that you have to do, but once you're aware of them, you can automate and systemize many of them so that as an organization, you can have a robust, standard way of dealing with data so that it doesn't get in the way of the effective operation of your business, but it does enable you to be compliant. One of the things that GDPR does change is the whole punitive field. Under the Data Protection Act 1998, there was no opportunity for the Information Commissioner to raise fines. In the UK, that was changed about 8 or 9 years ago when a separate piece of legislation gave the ICO the power to levy fines of up to £500,000. And in the last couple of months, for the first time ever since she had that power, she's been levying fines right at the top end of the range. Typically, she hasn't fined anybody more than 80% of the maximum £500,000, but in the case of both Facebook and Equifax, the fine was the full £500,000. We think that's her way of suggesting that under GDPR, she should be expected to be severe rather than lenient. And severe is potentially quite significant. There are two levels. You might think of it as tariffs for fines under GDPR. The first level is up to 2% of global turnover, or 10 million euros, whichever is the larger. And that's for a whole range of transgressions, including not reporting a data breach, not putting in place data protection by design and by default, not carrying out data protection impact assessments if you should, not having a data protection officer if you should, very specific faults, each of which can generate a fine of up to, I'm stressing, up to 2%. Then there are the more severe fines, which go up to 4% of global turnover, or 20 million euros, again, whichever is the higher. And this is focusing on breaches in three areas. The first is breaches of the rights of data subjects. The second is breaches of the one or more of the 6 data protection principles, and I'll come on to each of those later on. The third is breaches in relation to the international processing of personal data. And that in particular is going to be an issue for companies and organizations in the UK post-Brexit, because the processing of data from the European Union into the UK, or the provision of services into the EU by the UK, will create potential transgressions of the requirements under that particular clause. So the potential fines are quite substantial, but they're not only fines. The Information Commissioner has the right to issue stop orders, to issue requirements that organizations change what they're doing, can carry out investigations, assessments, and do, broadly speaking, within the general legal context of the country within which we're operating, take whatever steps might be necessary to ensure the law is properly and appropriately enforced. And the game changer for most organizations is the recognition that if you have a personal data breach, you can no longer sweep it under the carpet and hope that nobody will find out. GDPR requires personal data breaches to be reported, and to be reported within 72 hours. Definition of a personal data breach is very broad. A personal data breach is any compromise of the confidentiality, integrity, or availability of someone's personal data. So if someone's collected their data, an organization has collected someone's data for a specific purpose and it's not available for that purpose, or it's otherwise compromised, that is a data breach. And in respect of data breaches, organizations have a number of obligations. The first is that if you're a processor operating under a contract from a controller, you have to report the breach, however serious, however unserious, to the data controller with whom you contacted as soon as possible, and certainly within 72 hours. By 72 hours, we're talking calendar hours. So if you identify a breach on a Friday afternoon, you'll be reporting it by Monday afternoon. The processor has no latitude. All breaches must be reported to the data controller. Data controller, either in dealing with breaches it has occasioned or those reported to it by a processor, has to assess the severity of the breach. If on assessing the breach it decides there is no risk to the rights and freedoms of data subjects, then it does nothing more. It simply makes a note in its log that that's the decision and how it was arrived at. If the decision is that there is a risk to the rights and freedoms of data subjects, then it's necessary to report the breach to the Information Commission, and that's within 72 hours of first discovering the breach. If it's identified that the breach also has a high risk to the rights and freedoms of data subjects, then not only do you have to report it to the Information Commission, you also have to tell the data subjects themselves. The law allows for you to do that by any means practical, so you might be able to email them all, but it might also be that the sensible way is to publish information in social media or in news or in press or in some other route which will ensure that all of the data subjects are made aware of it. And that's obviously a requirement, because if somebody's data has been breached, they need to know as soon as possible so that they can take steps to protect themselves from the consequences of that breach. So the breach reporting requirements are very significant. Most organizations won't have, but do need to develop a data breach reporting capability. We think of it as being breach ready, recognizing that you're going to be breached, so you need to have an escalation process so that you can be sure that breaches will be recognized, they will be assessed, and they will be appropriately reported. So the timeline as GDPR came into effect is worthwhile just stopping for a minute to recognize that it entered into force on the 24th of May, so it applied from the 25th of May 2018, 2-year gap between the 24th of May 2016 and the 25th of May 2018. The Information Commissioner, we believe, has the view that everybody's had 2 years, now 2.5 years to get compliant, so there isn't really an excuse not to be compliant with GDPR. And you'll find that if you have to report a breach, essentially what you'll then be doing, if the breach merits investigation, is justifying to the ICO why you weren't negligent. You'll be explaining why you did everything that you could have and should have done to protect that data, and the extent to which you're successful in that making that argument will be the extent to which you're able to whittle the level of the punitive fine down to something significantly less dramatic than the 2% or 4% that we've talked about. So, as I said, it starts with the rights of data subjects. You and I, we are living human beings, so we have rights, and the controller has to take appropriate measures to provide us with any information that will help us understand what processing they're going to do with our data, and that information should be provided in a concise, transparent, intelligible, and easily accessible form using plain language. So a privacy notice is the method by which an organization would normally do that. It would be on your website, it might be sent to the data subject, should be written clearly, written in complicated legalese so that the data subject doesn't understand it, won't work. Your lawyers might like it, but your the Information Commissioner and your data subjects won't. So it has to be a transparent document, intelligible, easy to understand and access. And not only do you have to set out what it is that you're going to do with the data that you're collecting, and you have to break that down into each of the elements of data. You can't say we're collecting your name, address, health statistics, where you've ever visited in your life, gender, political beliefs, in order to sell you a book. Because quite clearly you don't need all of that data in order to sell someone a book. You're only allowed to collect the data that is necessary for the specific purpose for which it's being collected. And you need to tell the data subject what it is. So the data subject has the right, first of all, to that information. What are you going to do with my data? They also have the right to access their data so they can see whether you're doing with it what you said you would. If there is an error in the data, they've got a right to insist on it being rectified or corrected. If the data is no longer valid for the purposes for which it was collected, they have, under certain circumstances, the right to require it to be erased. The right to be forgotten, or the right to erasure, is not an absolute right. It applies only under specific identifiable circumstances. If there's an argument over the validity or accuracy of the data, during the period of that argument, the data subject can restrict the processing, say that you're not to process the data until the issues have been resolved, or the objection which they've raised to the processing has been dealt with. Their objection could simply be that they don't wish the data to be processed, and under certain circumstances you must therefore stop processing the data. Not under all, it will depend on the lawful basis on which you're processing the data. And data subjects also have the right to, under certain, again, restricted circumstances, get their data back from you in a machine-readable format, and they have the right to be informed if the processing you're doing is likely to result in any automated decision-making, and that includes profiling, as well as the anticipated consequences of that profiling. So if the data is to be used as part of a credit reference check, or in order to determine whether or not somebody should get a mortgage or be allowed to rent a flat, all of that has to be disclosed, and the likely consequences of how the data that's collected and the way in which the data is collected will be used, the likely consequences to the individual also need to be set out. So very specific rights, and data subjects, if you're processing the data on the basis of consent, they can withdraw consent, and I'll come back to briefly to consent shortly. But above all, they have a right to make a complaint. And the ICO encourages data subjects to complain to the controller first, and it's always the controller that's on the hook, much more than the processor. But you can go to the Information Commissioner and complain and say, I've talked to my controller, and they're not giving me the information I need, please do something about it. And the Information Commissioner is obligated to investigate. They've got a certain time period during which they can investigate. If they don't do that satisfactorily in the time frame, data subjects can seek a judicial review of that behavior. So the reality is that for most organizations, the possibility of a data subject bringing an action is one of the things that should keep them focused on the need to be properly GDPR compliant. You can't control where the problem might come from. And as a controller, you're required to facilitate the exercise of data subject rights. So you have to make it easy for them to effect their rights. You can't make it difficult or complicated. That's all part of the requirement around transparency. So breaches of the data subject's rights, that leads to fines up to 4%, as do breaches of the 6 data processing principles, or what's sometimes called the principles of accountability. In Article 5 of GDPR, it says the controller has to be able to demonstrate compliance with these 6 data protection principles, and it calls the requirement to demonstrate compliance with accountability. And accountability is also about governance. It's about the way in which the board of the organization makes sure that it's made proper decisions around the protection of personal data. The 6 principles start with the requirement that personal data is processed lawfully, fairly, and transparently. Lawful includes direct marketing. There's a lawful basis for processing in direct marketing. If you've collected the data as part of a contract, that would be lawful. There needs to be something recognized in law as the basis for the processing of the data. It's the second principle that has the biggest impact. And if you make sure that the data you collect is collected for specific, legitimate, and explicit purposes, you'll find you can't go far wrong. Legitimate purposes are, broadly speaking, defined. They, in the biggest possible way, come down to if the way you use the data is in line with what the data subject was expecting when they gave you the data, it's likely to be legitimate. It has to be lawful, so you can't use the data to break the law. You can't use the data that somebody's given you, even if they know that's what you're going to do with it, in order to sell prohibited drugs, for instance. You have to be explicit about what you can use the data for, and legitimate purposes, as I said, they could include direct marketing. They include tracking the behavior of people on your network. You have a legitimate interest as an employer, for instance, in making sure that people who use your network do so in line with an acceptable use policy. The data you collect must be adequate for the purpose, limited to what's necessary. You can't collect more data than might be necessary, and you need to be clear, if you're collecting data for a number of purposes, what data you collect for each of those purposes, and you can't bundle them all together. You have to separate them out as steps. So if you're collecting data because you need to process a payment card transaction, that means you'll need to know their home address and their payment card data. But you also want to deliver it to them. That means you need a delivery address. You might need the telephone number of the person who's going to take delivery. There's 2 different sets of data with 2 different purposes. You might retain those data for different periods of time. So you might keep the payment card transaction data for as long as you're required to under the law with respect to accounting records. But delivery records and logistic records you might not need to keep for longer than a year. So you will have a retention period that is appropriate to the purpose for which you collected that data. And that's the fifth of the data protection principles. And that's a sensible principle to observe, because the fourth requires that you keep data up to date. And if you no longer need the data, but you keep it, you should really be keeping it up to date. So much better to have a retention policy which leads you to dispose of or delete securely data that you no longer need. And finally, the sixth data protection principle is that personal data should be processed securely. Securely includes techniques like encryption, pseudonymization, and so on, but it's up to you. You notice the word appropriate. It's up to you as the data controller to determine what's an appropriate level of security in respect of that data. Back in January 2017, the Information Commissioner, talking to the Institute of Chartered Accountants of England and Wales, said, "We know that this legislation creates an onus on companies to understand the risks they're creating for data subjects and to mitigate those risks. It's not about data protection as a tick boxing exercise, but it's about building data protection into the fabric of the organization, so it becomes part of the culture of how the organization deals with privacy. Organizations need comprehensive but proportionate governance measures, and that means a change to the culture of the organization with data protection embedded in the company's overall systems approach. So Information Commissioner is saying very clearly in 18 months ago that organizations need to make sure that they are turning privacy into a core part of how the organization deals with personal data, not something which is dealt with as an afterthought, but fundamental to what you do. And just thinking about how you make sure you demonstrate that you are reserving the principle of accountability would start with making sure data protection or privacy is on the board agenda. There's preferably a member of the board who is accountable for ensuring that data protection is dealt with properly across the organization. You might need a data protection officer. You might have, instead, if it's not a DPO is not mandatory, you might have a privacy manager. And you'd build a privacy compliance framework. And a privacy compliance framework would combine an information security management system with a personal information management system. And there are national and international standards that can be used to give you an easily understood and easily followed framework for managing personal data securely. You need to keep records of the processing of data. Article 30 of GDPR sets out some very specific records that you need to keep. You need to have a method of identifying breaches and responding to incidents, and you can think of standards like Cyber Essentials as being an absolute minimum as in terms of demonstrating that you've taken basic steps to meet your compliance obligations. If you're processing payment card data, you should comply with PCI. If you're in the NHS, you should implement the DST. So data protection by design and by default, driven by data flow audits, driven by data protection impact assessments, and DPIAs are mandatory for many organizations, and they're a legal requirement for all organizations where, for instance, you are combining systems, you're creating new systems. Basically, you're creating new risks, particularly high risks for data subjects. So no organization can think of itself as being immune to the requirement to carry out DPIAs. It's likely that almost any organization could have to do that. So understanding how to do it, building it into your processes, embedding it by design and by default is a smart move. I said I'd come back to consent, and under the Data Protection Act 1998, we tended to rely on consent as the lawful basis of processing. That's not so smart under the new regime, because if you're processing data on the basis of consent, the data subject's entitled to withdraw consent at any time, and you have to stop processing their data. Consent has to be freely given. That means it has to be given by one party to another without pressure. That means that local authorities or central government can't rely on consent. It also means that employers can't rely on consent to process employee data. The relationship between employer and employee is not equal. Instead, you can rely on legitimate interest, and there are a number of alternatives set out in Article 6, which describe the lawful bases of processing, such as there is a contract between controller and data subject. The controller has a legitimate interest in the particular processing. There are the vital interests of the data subject to protect, and so on. There are a number of very specific grounds for processing, and you should consider those as to whether they're applicable before you go to consent. Consent has a very high bar. As a processor, you want to make sure that you've contracted with the controller, because then all you have to do is comply with what the controller tells you to do. If you're a controller, you're the party that's obliged to work out the lawful basis of processing and to make sure that appropriate levels of security are in place for all the processing which you do. If you think you're a processor but you can't work out which organization you're processing data for, you potentially have a problem, because in the absence of a contract, it may be that you're a controller, and if you haven't taken appropriate measures, you may just find yourself looking at a fairly substantial fine. So controllers are responsible for making sure that processors comply with the regulation and have a legally binding contract which the controller enforces. There are particular issues around extraterritoriality, where the controller needs to ensure that the data will be protected outside the European Union legally to at least the same level as inside it. And that's one of the reasons why the European Union enters into what are called adequacy agreements, or recognition that particular countries have data protection regimes which are adequate in comparison to that of the European Union. So consent, as I said, very high bar. You have to be able to demonstrate that it was given. Silence does not constitute consent. Pre-tick boxes don't constitute consent. You can't force somebody to consent by saying, we won't let you buy this from us unless you consent to the processing of their data. None of that is consent. Consent has to be very clear, very unambiguous, and must be based, as I've said, on written information which is clearly provided. Children under 16 across the European Union can't consent to the processing of their data for the purposes of an information society service, unless the member state of which they're a citizen decides otherwise. The UK decided on 13, that's the lowest you can go, and that means that anybody under the age of 13 can't sign up to Facebook, for instance, without the explicit permission of a parent or guardian or somebody authorized to give permission on their behalf. And the provider of the service has to make sure that they have a proper method for establishing that the person giving consent is the correct adult. There are also prohibitions set out in Article 9 for processing certain types of what used to be called sensitive data, racial information, genetic information, political preferences, so on, and all those kind of things. And the GDPR prohibits the processing of that data. It doesn't say you can do it as long as you do it carefully. It says you may not do it unless you have a specific basis for doing it, in addition to meeting the requirements under Article 6. And those might include the vital interests of the data subject. There are some similarities between the options in both Article 6 and Article 9, but unless you can identify that you've got one of those exceptions in place, you may not process any of the special categories of data. You note that sensitive data is now called a special category of data. I talked about transparency, and transparency under GDPR is a very specific thing. It means clear, easy to understand, concise, intelligible, not long, not written in complex legalese. But it also means that when a data subject wants information about the processing of their data, what's called typically a subject access request, then you have to respond. And you've got a limited period within which you can do that. You've got 1 month from the point at which you receive their response, their request, and their request note does not have to be in writing. It can be verbally, it can be however they want to leave it. You are entitled and should make sure that they are who they say they are, and that you only release data about somebody into the hands of somebody who's entitled to receive it. Otherwise, you have a data breach. But you've got a month in which to do it, and the rights to access, rectification, erasure, and so on all have to be dealt with alongside how you facilitate the exercise of the subject access request rights. So facilitating rights, but also building data protection by design and by default into how the organization operates. We've talked about controllers and processes outside the European Union. They need to have a representative within the European Union. So again, if we come to Brexit and you're providing services from the UK into the European Union, after the date of Brexit, you'll need to have a representative organization within the EU who can act, if you like, as a postbox on behalf of data subjects in the EU or supervisory authorities. The representative service doesn't have to enforce on you compliance, but there's simply a representative that you have appointed in order to ensure that you're able to easily comply with GDPR. Much more importantly, data protection by design and by default is looking at data protection impact assessments, mandatory for certain organizations, and in each country the supervisory authority identifies which they are, but broadly speaking they are those organizations which are processing high volumes of special categories of data or are in critical national infrastructure type environments, and technologies and processes that are likely to result in a high risk to the rights of data subjects, such as mass surveillance of individuals. All of those have to have a data protection impact assessment. And a DPIA is simply a structured process around establishing the risks that there might be to that data, how the risks can be mitigated, and making sure that the mitigations you've chosen are put in place and are properly effective. GDPR applies to all data. It doesn't matter when you collected the data, any data that you're processing, and remember that storing data counts as processing, as of the 25th of May falls within scope for GDPR. So however long ago you collected it, you need to have gone back and made sure that the way you're processing that data is in compliance with the requirements of GDPR. That means you may have to design data protection in retrospectively, you may have to change processes and documentation, you may have to go and talk to data subjects and say, this is what we're doing and here's where the privacy notice is and that's how we're going to go on dealing with it. Every bit of data you're processing is subject to the GDPR. And that kind of brings us back round to security. In two areas, GDPR talks about the requirement on organizations, controllers and processes to make sure that they put in place appropriate security for the personal data, taking account of the range of risks and the range of threats, and it's up to you to do that. GDPR doesn't tell you what to do, it tells you how to go about determining what to do. And this is a key area for making sure that you've got proper documentation in place where you can use standards, use tools, all of which will enable you to demonstrate that you tried to tackle this in a consistent way rather than just let it become something which you made up as you went along. Encryption is a very good way of protecting data. It's thought by the supervisory authorities as being effectively putting data beyond risk. So you should think about most databases, most data in flight as well as at rest. Can we encrypt it? Can we regularly test, assess, and evaluate what we're doing around information security? How do we do data audits? What type of penetration testing do we do? All of those are ways not just of making sure you are compliant and secure, but of demonstrating that you've taken appropriate steps. Remember the principle of accountability to secure personal data. And that takes us back to the privacy compliance framework idea, which I mentioned half an hour ago as being a combination of a personal information management system and an information security management system, which is designed to ensure that the 6 privacy or data protection principles are implemented through a set of policies, procedures, controls, and records within a broad governance, risk, and compliance framework inside the organization. Of course, the idea of accountability brings us around to data protection officers, and a DPO is identified in the regulation as being a requirement of organizations that are processing high volumes of special categories of personal data, of public authorities and the like. It's mandatory for those organizations to appoint a DPO. Many other organizations won't appoint a DPO because you don't have to, but recognize that it's a sensible step to appoint a privacy manager, remembering that if you call someone a DPO, even if you don't need to have one, they'll be bound by what the regulation says a DPO has to do. So a privacy manager is probably a good practice appointment outside the mandatory ones. Most staff dealing with personal data will need training, HR, marketing, all of those people. And staff, of course, will need training in how to manage data. They're going to be dealing with phishing attacks. They're going to be collecting data. They should all be exposed to staff awareness training. One of the questions in the breach reporting form is, when did the persons involved in dealing with this data last receive appropriate staff awareness training? So there's the message for you to think about. And how do you demonstrate compliance? Well, it's a law. So ultimately, whether you're compliant or not is going to be a decision made by a judge. You can't, and there is nobody outside of a law court who can certify that you're compliant. What they can do is they can certify that you've complied with a management system which is designed to deliver what looks as though they are the requirements of the regulation. BS 10012, a British standard for personal information management system, is one such standard. ISO IEC 27001 is a standard that delivers risk-based information security management system. So codes of conduct and certifications can be used to demonstrate compliance, and there are likely to be new services and standards emerging across the European Union which will be appropriate for organizations looking to demonstrate that they've taken sensible steps. The fact that you're certified, of course, doesn't mean that you can stop doing everything you need to do to comply, because you need to continue. We talked about transfers. If you're transferring personal data outside of the EU, it needs to be on the basis of an adequacy finding that the country it's going to has been identified as having an adequate data protection regime, and the transfer of the data alternatively has to be subject to the same safeguards as those which were in place when it was collected. And it's up to the data controller to ensure that that is the case. You can't allow the protection of personal data to be undermined. There were, for instance, in terms of the US has no adequacy finding. It doesn't have an adequate federal data protection regulation, but the EU and the US put in place what used to be called the Safe Harbor Framework, which was found wanting back in 2015. Since the July 2016, the EU and the US has had in place what's called the Privacy Shield Agreement, which says that US organizations which register under the EU-US Privacy Shield and comply with the GDPR and certify that they're complying with the GDPR can be treated as though they're operating in an adequate country. That Privacy Shield is subject to review on a regular basis by the European Union, and is not guaranteed to remain in place forever. It's the independent supervisory authorities who, as I indicated, are in charge of making sure the regulation is applied effectively across the European Union. One of the other things a supervisory authority can do is act for organizations which are operating in multiple states. So you can, if you're providing services into Germany, France, Holland, Spain, and Italy, for instance, rather than dealing with 5 different supervisory authorities in respect of a breach, you could decide that you're going to ask the Irish, if you're based in Ireland, maybe, supervisory authority to act as your lead supervisory authority. One of the requirements is that a lead supervisory authority must be the supervisory authority of a member state of the European Union. So again, after Brexit, it won't be possible to ask the ICO to act as a supervisory authority across the European Union, which is a bit of a bore, but there you go. So independent supervisory authorities are a legal requirement on member states of the GDPR. And then finally, the EDPB, as I've said, exists to ensure there's a level playing field across the European Union, so that all data subjects know that their rights will be dealt with consistently in any member state, and any organization operating inside the European Union will be able to work to a consistent standard, knowing that it doesn't have to do things differently in Germany than it does in France or the United Kingdom. The ICO made the point that accountability is expensive. It encourages an upfront investment in privacy fundamentals, but also made the point that down the track, that will lead to organizations performing better, costs will go down, you'll have more people coming to you because you respect their privacy, you're much more likely to be a winner in the long run. But hey, she said, if you don't, we've got a big stick. We've demonstrated in the past that we're happy to use it. You can rely on the fact that we will use it. So if you don't want to comply because it's in your best interest, then comply because you want to avoid the regulatory stick. And do bear in mind, she said, that we're not going to be looking just at the breach, we're going to be looking at the cause of the breach. So you might lose a laptop, and that only exposes a few thousand people's data, but when we investigate and discover that you've got 500 laptops, none of them are encrypted, you've never done a risk assessment, actually we're going to treat you as being substantially negligent in respect of the way you manage very large quantities of data, and the fine will be based on that. So GDPR is something to be concerned about. The first major fines are expected sometime just before Christmas. We think there will be some coordination among supervisory authorities around the European Union, but the ICO has already taken first legal actions to prohibit processing by one company. So GDPR is already being enforced practically. The reason for delay between the 25th of May and the announcement of fines is, of course, that breaches have to be investigated. There are conversations to be had and assessments to be made before the right size of fine can be established. What do? Well, start with a governance framework. Get the board on board, get board awareness going, make a risk register, build an accountability framework, review what you're doing, appoint a senior data privacy officer, do a data inventory. What data are you holding? Which processes have you contracted with? What data are you holding that you can't possibly have a lawful basis for holding? That might be data you've had for the last 10 years, you never got permission from, and you can't work out why you've got it or how you're going to do it. That might be data that you don't have a lawful reason for holding. Work that out, decide what you're going to do, audit what happens with data flows. Make sure you know who can see data, where it goes to, and you can determine whether you've got an appropriate set of privacy statements in place and you're protecting data appropriately. Do a gap analysis between what you're doing and what your risk assessment tells you should be doing, making sure that you've got robust privacy notice, proper subject access requests, you've got records of processing, do a data protection impact assessment wherever you need to. If you don't need to right now, but you say got an IT project running that should have had one, add one into the mix, try and build all of that into what you're going on. And wherever you have gaps, remediate. The compliance project will take most organizations between 6 and 12 months, and that's from the point of having completed a gap analysis. Put in place appropriate cybersecurity measures that enable you to demonstrate that you've taken appropriate steps to secure the data. Test how your data breach response process will work. Make sure that you can identify and respond to a breach within 72 hours. You know how to report it, who to report it to, and then put in place a process for continually monitoring and improving your compliance activity. Think of GDPR compliance as a journey, not a destination. What you have to do over the next 12 months is the start, and what you have to do over the next 12 months. Privacy and privacy management, we expect in most organizations to become a bit like health and safety has become now, something which is fundamentally part of the core processes of how the organization operates. There are lots of ways we can help you. We have pocket guides and implementation manuals based on many years of assistance to organizations and work substantially in the GDPR arena. We have pre-written documentation policy toolkits, a compliance gap assessment tool. We can provide you with training, basic foundation training for most people, implementation training for those who are going to lead or work in an implementation project, workshops on how to do data protection impact assessments, and of course, a substantial range of consultancy offerings, all the way from doing gap analyses through to helping hands-on implement specific parts and aspects of your GDPR compliance framework. We offer data protection officer as a service. We have an in-house law firm that enables you to get very specific legal advice at a much more practical price than is typically available. All of that's available as part of the broad range of GDPR-focused services from us as an organization. And that, ladies and gentlemen, brings me to the end of what I plan to say. There are a number of ways that you can follow us. There's lots of free information on our website. Please do feel free to access that. Do follow us through our various social media. But that then brings me to questions. If you've got questions which you haven't yet asked, please do take the question bar in the GoToWebinar box on your in the control panel. Put any question you've got in there, and I will answer any questions there. I'll share the question with you, and then I'll tell you what the answer is. So if you've got a question, that's the place to put it. I work in fraud prevention. Regarding data requests from the police or other agencies that involve sharing data on customers for the prevention or detection of crime, I'm wondering what requirements are needed to warrant such a request and what is required on the request itself. Should I receive or wish to send one myself? Well, first thing is you need to be clear that you do actually have a lawful basis to collect that data, and crime prevention is a lawful basis, but you need to be clear about specifically what information you're collecting. You need to be clear about what you're going to do with it, how you're going to use it, and you need to think about whether or not the data subject is entitled to be told. They might not, but they might be, and it's an area on which, because it's not right in the mainstream, you should undoubtedly take very specific legal advice that will look at your specific circumstances, either in terms of providing information to the police, because they're not necessarily entitled to all the information they want, and how you might go about either providing it or asking it, and the circumstances under which you do that. Because, of course, many of these circumstances can lead to court cases later, it makes sense to put the time and effort into getting the specific circumstances right before you're dealing with any such issue. So, partial answer. Any other questions, folks? If you have, please do feel free to use the Q&A section in the control panel. But if there aren't, I'm going to bring today to a close. I hope you found the webinar useful. If you really haven't got started on GDPR yet, I suggest that you do get onto our website, get hold of some of the tools or services, get started. You don't want to be further behind than you are. If you already got started, then do get yourself down towards the end. The faster you're able to demonstrate proper compliance and data protection embedded by design by default, the better. I wish you luck on your journey. If there are ways that we can help you, please don't hesitate to come back to us. But thank you for joining us, and have a good evening. Bye-bye.